Um, Thank you, first of all, for the invitation to this very high-profile event. Secondly, I wanted to say I would not consider myself an expert in hate speech, and what I will be presenting is work in progress. So I'm going to argue, perhaps controversially, that the network enforcement law, the German network enforcement law, is building a bridge between two very different speech traditions, and that is, on the one hand, the American speech tradition, and on the other hand, the European one. The argument is based on the idea that we are not talking here in the speech traditions about a binary opposition. America does not love hate speech, and whilst Europe may hate hate speech, America doesn't love it. What I will be arguing, based on a historically grounded conception of citizenry, that they have different primary fears, and these primary fears are not sitting on the same scale. In other words, they are not in direct opposition to each other and thereby can be bridged. Why does it matter? Why should it matter that the network enforcement law is palatable to Americans? Yeah? It matters because we are talking, it's applicable to American platforms, yeah? And American platforms are requested to cooperate. And here I want to use a quote from David Beetham's book, The Legitimation of Power, from 1999, when he wrote, "When legitimacy is eroded or absent, power does not necessarily collapse or obedience cease, since it can continue to be kept in place by incentives and sanctions. However, coercion has to be much more extensive and omnipresent, and that it is costly to maintain. Less dramatic but equally important is the effect of a lack of legitimacy, the effect the lack of legitimacy has on the degree of cooperation and the quality of performance that can be secured by them." So it does matter that American platforms view European laws, of which the German network enforcement law is the first one, but more to follow, view it as legitimate or has certain legitimacy. And I'm going to try and argue that there is, perhaps even from an American perspective, a legitimacy there. Now, what are the internet background drivers that have given rise to these legislative initiatives? And I identified two significant pressures. One pressure is that the internet has led to an increase in the amount, visibility, and permanence of unfiltered public speech, and that includes hate speech, and thereby confronted European hate speech prohibition with a problem of a different order of magnitude, one that demands a paradigmatic rethink of regulation. So that's one thing. European regulators need to think, how can we deal with hate speech? On the other hand, you have also the fact that the internet is global, has facilitated global speech, and thereby it is no longer possible, or let's say it is more difficult, to keep the territorial silos in which different speech tradition could exist in relative harmony. So before the internet, it was okay for America to have its First Amendment, relatively speaking, and for Europe to have a completely different speech tradition. So that is no longer the case after the internet, and thereby there are these two pressures that have led to new regulatory initiatives. Now, before I come to the network enforcement law, I want to briefly talk about the different speech traditions, the European one on the one hand and the American one on the other hand, and I want to argue that they're both based on different understandings of citizenry, and they are historically grounded and they have legitimacy in their own right, even if they're contrary to each other. I will be relying on James Whitman's article, brilliant article written on two Western cultures on privacy. The arguments which he puts forward in relation to privacy are also applicable in relation to speech, especially hate speech regulation, are also applicable to equality regulation. Now, he says that in relation to privacy, but I apply it now to free speech, that European speech cultures may be read against the historically strict hierarchical societies, whereby dignity and honor were the prerogative of the aristocracy and the upper middle classes. Sometime during the 19th century, there was a growing pressure towards the democratization of dignity and honor. And of what Whitman calls of the leveling up, that everybody had as a basic right of being a citizen an entitlement of being treated respectfully, yeah? And that doesn't mean that you need to respect the actual views of people, but that you respect them as members, equal members in society. Equally, that leveling up of dignity means that insult and humiliations are actually tools of disempowerment and exclusion. They are ways of silencing minorities. On that basis, hate speech regulation seeks to accord the same level of prohibition, seeks to accord the same level of respect to all members of society and allow equal participation in society. For Whitman, in his article on privacy, he talks about, he says, what is the primary threat to the continental European understanding of privacy, and he identifies the media. Now, I feel that Whitman's preoccupation of finding a primary enemy is, in fact, provides a very peculiar American outlook, because in an American context, it doesn't matter what is said, but it does matter who says it or who does the censorship. Yeah, so American speech culture is very much concerned with who is the one who censors speech rather than what is censored. From a European perspective, it's not the who question. There's no primary enemy. The primary threat lies in the unmoderated presence of hate speech in the public domain. So in other words, there's a what threat. Yeah, what is present out there? It doesn't really matter where it comes from, but it's perceived as a public threat that needs to be dealt with. Okay, coming now to the American background to the speech tradition. American speech tradition is very much liberty-driven. The American preoccupation with the state as the primary threat to free speech is legally anchored in the First Amendment, which shields citizens from official intervention in absolute terms. So there are no exceptions, or very, very few limited exceptions. Now, the First Amendment, passed in 1791, only emerged in its present absolute interpretation in the second half of the 20th century, with cases like Brandenburg in Ohio and New York and Sullivan. However, even today or even before, First Amendment jurisprudence is deeply inscribed with settler mentality. And the settler mentality is a mentality of the ideal of hardiness, self-sufficiency, self-reliance, and by implication of self-rule and distrust of government. So Justice Brandeis, in the case of Whitney and California of 1927, which actually concerned the prosecution for someone for distributing communist speech, nevertheless laid the foundation for the absolutist interpretation of the First Amendment. And the way he writes about it is very much in terms of the self-reliant settler. Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. Two courageous, self-reliant men with confidence in the power of free and fearless reasoning applied through the processes of popular government. No danger flowing from speech can be deemed clear and present unless the incident of the evil apprehended is so imminent that it may befall before there is an opportunity for full discussion. So this is a very clear construction of the First Amendment in terms of the settler. Now, looking at the European preoccupation with dignity and leveling up of dignity, that, of course, doesn't make any sense to American settler mentality, because for the American settler, the universal immigration status, the common hardship in a hostile environment acted as a very powerful equalizer. And America actually sees itself as at its root and at its inception as deeply egalitarian. So, you know, dignity, in fact, Whitman in a different article says that America actually cultures an environment of disrespect rather than an environment of respect. So it's completely inversed. Now, unlike Europe, American speech regime is not concerned with what speech is or is not in the public domain. It doesn't matter. It's not concerned with that. It is happy for private actors to take down hate speech. Yeah? It's not against private censorship, and the First Amendment doesn't apply to private actors. It is very much concerned with the state, and it wants to take the state out of interferences with public discourse, because ultimately there is a sort of skepticism about the ability of government institution to distinguish between good and bad, sound and unsound, and so on. So government is taken out. That is justified, much like actually in Europe, the hate speech tradition are justified by reference to multiculturalism. So Justice Harlan in Cohen in California has argued the First Amendment is the ideal power, or is a powerful medicine in a society as diverse and populous as ours. He then goes on, free speech is designed and intended to remove government restraint from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hand of each other. So we are the arbitrator of what shall and shall not be said. And that is in the hope that the use of such freedom will ultimately produce a more capable citizenry. So here you have yet again a justification in terms of citizenship, empowered citizenship, what you might say the opposite view on speech. But are they actually opposites? There is, of course, a direct confrontation when it comes to the regulation of hate speech. While America say you must let it stand, Europe say, no, you must take it down. In fact, the primary preoccupation or the primary fears that underlie it are very different. Europe is afraid of what is in the public domain. America is afraid of who interferes with the speech. So these are not fears that sit on the same scale. These are fears that are on different scales and come to clash only when government is treated as the agent, the actor that needs to deal with hate speech. If you take government out of it, you suddenly have the possibility of hate, and you can still deal with hate speech. You have the possibility of a regime that is not a major threat to America, and that is also appeasing the European fear. And I'm arguing the network enforcement law does just that. Well, sort of, not quite. It's not a perfect regime. So the German network enforcement law requires social media platforms with more than 2 million German users to remove hate speech and other illegal content in response to user complaint. The time span, as we might have heard already, is 24 hours for manifestly illegal content and 7 days for illegal material. The legality is reviewed by the platform in light of content prohibition under the German Criminal Code. The relevant one for hate speech is section 130. If platforms do not comply with their obligations, they can be fined up to £50 million. Now, the interesting thing about this law is that it has triggered complaints of undue privatized censorship from a European perspective, and from an American perspective, it has triggered complaints of undue public censorship. So you have one law that has, in fact, that doesn't seem to make anyone happy. And I'm saying in not making anyone happy, it is actually what has happened there, it's striking a compromise. Now, going through the German undue privatized censorship. With privatized censorship, there's generally the danger of overblocking. There's also the objection that the judicial function is outsourced to a private entity. So a governmental function is handed over to a private entity and thereby lacks the accountability which you would normally expect from a public entity. Now, coming to the first point about overblocking, there is empirical evidence to suggest no overblocking has occurred, which is interesting because everybody sees, well, if you fear that you may be held liable for content which you have not taken down, you will err on the side of caution. Now, here the interesting thing is that the Act actually doesn't say that anyone is liable for not taking down particular content. The Act doesn't create liability for a failure to take down a particular act. It creates obligations that are almost entirely process focused. It creates the obligation to publish transparency reports. It creates the obligation to place adequate processes for allowing and dealing with user complaints, for the appeal of the decision, for arbitrating between users making complaints and whose content, and those between the user making a complaint and the publisher of the material. It creates obligation to keep these processes under review and an obligation to remedy organizational shortcomings. It creates obligation to train and supervise content reviewers and to have a contact person in Germany to deal with information requests. So the breaches of duty in this case are not a breach of duty and attendant liability for failure to act on a particular hate speech site. The breaches of duty are all process-focused, and thereby actually platforms do not have an incentive to over-regulate. They might have an incentive to underblock actually, because there's some evidence that suggests that, for example, Facebook in the first year after the Act came into operation had 1,000 complaints. Whilst I think YouTube and Twitter had each, in the same period, 500,000 complaints. There's obviously something wrong there. Yeah, but in any event, I think the overblocking complaint has not been borne out, and I think that is but due to the nature of the compliance regime. Now, of course, when you look at what the obligations are, in fact, there is a privatization of a judicial function. Yeah, and this is a complaint utterly justified. There is indeed very little oversight of actual decisions. Yeah, decisions made by the platform are not reviewed by a public body. And in fact, if that was the case, that would really defeat the whole point of the exercise, because you're delegating this because it's too much for a public body to do. So there is a certain trust you're placing in this private body. This is a significant departure from traditional law and traditional ways of dealing with hate speech. By implication, the privatization of the function also is evident in that, in fact, platforms have much discretion in how to interpret hate speech, how to interpret something as manifestly illegal. The actual decisions are not checked. The privatization is also interesting in that platforms are not expected to be proactive. Platforms only respond to user notices. So a platform doesn't need to monitor their site. They might monitor their site under their own community standard, but the law itself doesn't impose an obligation. So if no user complains, a platform would not do anything. Now, if you look at it from a German perspective or from a European perspective, in principle, if it works, you might say that this law deals or appeases the primary fear which a European viewer has, and that is the presence of hate speech in the public domain. It does so via a different actor than the traditional actor, but it gets the end result. Now, from an American perspective, as I already said, from an American perspective, the network enforcement law would be considered undue public censorship, because here actually government delegates out sources what it cannot do itself. So under the First Amendment, America could not censor hate speech. So funnily enough, what you have here is that it's the opposite to the European way of thinking about it. Here the state outsources what it cannot do itself. From a European's perspective, you might think that the state outsources what it should do itself. Yeah, there's an expectation of the state that it does that. Now, no doubt, strictly under First Amendment lens, the network enforcement law would be struck down as unconstitutional. However, I want to say that this law actually goes some way to appeasing the American fear of government involvement, and it does so for precisely the same reason as the Europeans think that it creates a threat, and that is through the privatized law enforcement. Platforms have significant autonomy of how they interpret the law. They have discretion. They're setting up a system, but this system is actually ultimately activated by popular government. Popular government is what underwrites the First Amendment. Yeah, that it is you, from the quote from Cohen in California, that it should be you and me who decide what should be online. So it is you and me who decide whether we make a complaint or not. Yeah, so it's very much driven by the user, by the individual, and thereby reminiscent of popular governments in government argument in support of the First Amendment. Now, I want to conclude. Good timing. I'm a bit blind, I can't actually see that. Okay. Now, Facebook has its community standards. I would argue that the network enforcement law incorporates or adds democratically legitimated actual community standards to Facebook's gatekeeping activity. Because when you think, well, Facebook had community standards, where do these standards actually come from? We've heard earlier from Professor Bolkin that actually they come from where most people complain. Yeah, these are global standards which Facebook has, but are these the standards which a European would accept as their community standard? So by incorporating, I suppose, the criminal law provision, you incorporate what I would argue are German community standards that are then enforced through the notice and takedown procedure on the platform. Now, I'm sure this argument can be taken apart. I just wanted to say that I think the platform goes some ways towards reconciling what is the American fear of state involvement and what is the European fear of having hate speech available unmoderated in the public domain. The network enforcement law builds a bridge. That bridge is not perfect. That bridge is a little bit fragile, but then I'm arguing this against the pressures, the new regulatory pressures to which the internet has given rise. Thank you.